that we're tracking. Breaking news coming in from the Delhi High Court. They're holding the government following the procedures prescribed under Section 69A of the IT Act in imposing the temporary ban on Telegram. The High Court has said that the reasons given by the government were sufficient in the emergency situation. They rejected challenges based on the alleged non-supply of reasons. Sambhav Sharma joins us on the broadcast to give us more on this. Sambhav, give us the details of what it is that we're tracking.
Well, absolutely. Here, the High Court is very much clear. We were discussing this Section 69A, and the High Court has said that government was empowered to use Section 69A of the Information Technology Act to direct blocking of the access to Telegram, and the test of proportionality which we were discussing is satisfied, is what the High Court has said. And the High Court has very clearly said that after considering all the arguments, the High Court finds that given the emergency nature, the reasons supplied are sufficient and the government has followed the procedure under Section 69A of the Information Technology Act, and the challenge on the ground of non-supply of the reasons which the Telegram has said in the High Court can't be held. So clearly no relief for Telegram from the Delhi High Court is the breaking news of currently this is what the Delhi High Court has said. And
right.
And also Section 69A, if the procedure is properly followed and government is empowered, because Solicitor General during the hearing has very clearly said that why Section 69A of the Information Technology Act was imposed in this particular case, and why only Telegram was targeted. Here the Delhi High Court has now upheld in a way that after considering the argument, the Delhi High Court find that given the emergency nature, now this is important, the High Court has said that given the emergency nature, the reasons supplied are sufficient and government has followed the procedure under Section 69A, and both orders are well founded and supported by reasons. So the government order of temporarily banning Telegram ahead of crucial NEET UG re-examination, which is to be held on 21st of June. Here, the High Court has upheld the reasons given by the central government and also the keeping the emergency nature of the situation in mind. The central government was within its rights to impose a temporary ban on Telegram, is Delhi High Court has upheld. And another very important point, Justice Tejas Karia, because the matter was before him day before yesterday, he heard yesterday in detail, he heard the matter, and now the judgment, government is empowered under Section 69A to direct the blocking of the access to Telegram, is what the High Court has said, and also the test of proportionality. And also the High Court has further said the government's measures are least restrictive in nature. So they are least restrictive in nature. It cannot be held that order is disproportionate. So very much clear order by the Delhi High Court on Telegram's petition challenging the government's order of imposing a temporary ban on Telegram ahead of the NEET examination on June 21st. Here the High Court has very clearly said that the government was within its rights to impose a temporary ban. Section 69A was properly followed, and keeping the emergency nature of the situation, government has gone with this move, and now no relief for Telegram from the Delhi High Court is what is the most important news of this time.
All right, absolutely. So there you heard it, my colleague Sambhav reporting from the Delhi High Court, where he's given us an update. The Delhi High Court has upheld the Telegram ban. Khushbu Jain, cyber law expert, is still with us in the broadcast. Ma'am, your first thoughts. The Delhi High Court has made it abundantly clear that there is a proper reason as to why they're upholding the Telegram ban. They have said that under the situation, which is there is emergency going on right now, under those circumstances, the decision has been made. How do you view it?
See, if you look into it, every government is entasked to perform its duty. And one of the duty is to make sure that the laws are implemented in a manner and public order is maintained, and emergency-like situation, they have to act upon it. And if it's within the defined law, I think if government do not act upon it, that's where we should start questioning it. Now, the scenario or the facts here are pretty much clear, where mishap was happening. There was a technical misuse of the platform. This is admitted part of it. There have been a to and fro discussions between the government and the Telegram for that matter. Still, if the solution was not coming, that's where Section 69A comes in place. Now, if you look into the Section 69A also, it is not something that they have an arbitrary or it's on the whims and fancies of the government to just exercise their power under Section 69 and block everybody and anybody. Section 69A has its own procedure in place. After the procedure, it also has to meet the proportionality part, what Sambhav was explaining before. Now, if I just take you to the basics of procedure, the procedure says that the request has to come from a nodal officer to the court if it's not an emergency. But if it's an emergency, they have to place it before the committee of senior officials, which issues the notice to the platform. It gives 48 hours to respond and then conducts a hearing. This is a normal procedure if there is not an emergency. But if you look into it here, a re-examination was happening, which creates a scenario of an emergency where this specific procedure of asking them to respond, and not that they were not being asked to respond, they were asked to respond into it. Now, after all these procedure also, if you look into it, the secretary of NEET has to approve or reject whether the recommendation that has come which comes to with relation to blocking under Section 69A, whether it is justified or not. Once it is approved, then a blocking order is issued to those platform or ISPs. Now, after all these also, there is a review committee which is chaired by a cabinet level, which periodically reviews whether the orders which were being passed in this periodic period were lawful and whether they can revoke them. Now, here also, if you'll see, it's not a permanent ban, it's a temporary ban which has been issued. And I think the whole purpose of bringing in 69A was this, so that the technology space or the space of the internet doesn't become a space of lawlessness. And that's what we are seeing from past 5 years, that these technology have become a breeding ground for criminals. Why? Because of that opaqueness and non-sharing of details with the government. That's where criminal feels this is the best place to commit crimes. And if you'll see the number, this gives us the understanding that the numbers have the way it has increased, it's unimaginable. The crime numbers, the cybercrime numbers, or those notorious activities by the criminals in the space of internet, despite having laws in place, still these numbers are increasing. Still, you and me do not get justice. We do not get the answers. Is because of the reason, because of this part. And that's where I think the emergency measure or law and order is where 69A power was given to the government, that you can exercise in that scenario, so that national security, sovereignty, law and order, emergency-like situations where they can have this they can invoke these rights.
Absolutely. Right, absolutely. I request you to stay on with us. We have some more breaking updates that we're tracking. The High Court rules that the orders are well reasoned, they do not suffer from non-application of mind, and that a platform like Telegram falls within the scope of information under the IT Act. Sambhav Sharma continues to be with us on the broadcast. Sambhav, give us the details of what it is that the High Court has said. They're saying that it does not suffer from law application and the orders are well reasoned. What more information are you tracking?
After detailed hearing today the order, the Delhi High Court, this particular judgment of in a way upholding center's temporary ban on Telegram. It's a very crisp judgment. I mean, the operative part of it, which the High Court has just now pronounced, the operative part of it is very clear. One, the Delhi High Court has upheld the center's temporary ban on Telegram, and also held that government followed procedure under Section 69A of the Information Technology Act. High Court has said that reasons provided by the government are sufficient in the emergency situation. So in a way, High Court has also held that yes, what the center said to the High Court yesterday through Solicitor General Tushar Mehta, that these are emergency situations, and that's why the High Court has now also held that reasons provided are sufficient for emergency situation, and rejected Telegram's petition a challenge to non-supply of reasons. So one challenge by Telegram was that there was no supply of reasons why this temporary ban on only this intermediary, that is Telegram, but why not on other intermediaries, was one major challenge of the Delhi High Court to this government's order of banning the Telegram. And court has also upheld, and Delhi High Court has said that center was empowered under a section 69A of IT Act to block access to Telegram, and test of proportionality stands satisfied. Also, High Court ruled that government action was least restrictive in nature. Another very important, it's a big win to center from Delhi High Court, because whatever major points raised by Solicitor General Tushar Mehta before the Delhi High Court yesterday, all these important points were taken care of by the Delhi High Court. Court held that center is empowered under section 69A to block access to Telegram, and also High Court has found that blocking orders are well reasoned and free from non-application of mind. This was also a point raised by Telegram yesterday, that there was no application of mind. But here the High Court is upholding what the center has said, and High Court is said that High Court finds that the blocking orders were well reasoned and free from non-application of mind. So application of mind, it was the bone of contention yesterday. Telegram was saying that there was no application of mind while blocking orders were issued.
Okay.
Center was saying it was well reasoned, and how Telegram is a preferred platform for terrorist-like activities is what Solicitor General said yesterday in a shocking revelation before the Delhi High Court, how 40 bots can be created by one user, and how this once user deletes media, everything gets deleted, there cannot be any access to it. So it is it's a preferred platform, a preferred destination for all illegal activities, is what Solicitor General said. And in a way, non-application of mind was a bone of contention yesterday, which Telegram was claiming. But here High Court has upheld that center applied mind while temporary banning Telegram, keeping the NEET UG paper leak case in mind, and the re-examination which is to be held on 21st.
All right. Okay. Samu, stay on with us. Let's now quickly take